Good morning, everybody. In the previous video, we were discussing about legitimacy of reservations under Indian Constitution. In continuation, we will discuss today regarding creamy layer theory as propounded by the Honorable Supreme Court in recent public interest litigation in 2024-25, and we shall also discuss the contents of Indira Sahni case. In 1992, in Indira Sahni case, the Honorable Supreme Court concurred that 27% reservations to OBCs was legal. It further said that in any case, reservations shall not exceed 50%. It further held that creamy layer theory is not valid. So these three have ruled the roost until 2024-25. But in a public interest litigation filed by one Mr. Ramashankar Prajapati, the Honorable Supreme Court held that the government should think of implementing the creamy layer theory. It pointed out that certain sections of scheduled castes and scheduled tribes have been unduly benefited by the reservation policy, while many other sections of the same community are swirling in poverty yet. It also questioned how the children of an IAS, IPS or other higher authority or children of high-ranking political leaders could be qualified to get reservations under reservation policy. Apparently, it appears to be justified, but it is the argument of a layman, I tell you. We have to test these propositions in terms of the Constitution and the law. In my opinion, creamy layer theory is yet amounts to providing reservations on caste lines. The Honorable Supreme Court has already said in 1951 in the case of Champakam Dorairajan case that caste-based reservations cannot be allowed under Indian Constitution. Then immediately Nehru swung into action and brought the first amendment of 1951 to say that it shall not prevent the state from providing reservations in jobs to any community which in the opinion of the state is not adequately represented in government employment. This was provided through adding of clause 4 in article 16. In my last video, I told you that there was a different angle to this first amendment. This amendment served dual purpose to the Congress party because the Parliament has passed the Representation of the People Act 1951. Under that Act, under section 28A, Dr. Ambedkar registered his political party by name Scheduled Caste Federation of India. That was a hint to Nehru. He immediately brought this first amendment to say that if anything is done for advancement of interests of scheduled castes, scheduled tribes, educationally backward classes and economically backward classes, that shall not be deemed violation of equality enshrined in the Constitution. So the narrative of political party of Dr. Ambedkar covered hardly 10 to 15% of the population of India, while narration of Jawaharlal Nehru covered about 80 to 85% of the population. As a result, Ambedkar's party was routed out in the 1952 first elections and Congress party won 75% of the Lok Sabha seats with 45% of polled and valid votes. Had all the opposition been united, that means had it there been a two-party system, Congress party would have not come into power. That is a different story. So, Dr. Ambedkar has started his political party under the name and style of Scheduled Caste Federation of India, which was a blunder. In response, Jawaharlal Nehru brought the first constitutional amendment in 1951, providing reservations to communities which in the opinion of the state are not adequately represented in government employment. And it is against the judgment of the Honorable Supreme Court in Champakam Dorairajan case that caste-based reservations cannot be provided under Indian Constitution. Instead of honoring the Supreme Court judgment with a small twist, again the Congress party started implementing reservations to castes in terms of the first constitutional amendment. Who should stop it? The person who has majority in the Lok Sabha has passed this bill, and who should stop it? In my opinion, it is the President of India who should stop it, because he has taken oath under Article 60 to preserve, protect and defend the Constitution of India and the law. None other than the Honorable Supreme Court itself that caste reservations cannot be provided under Indian Constitution. Then how is that the Parliament can pass a law against that? As a result, there has been social discrimination, apartheid in India. People are hating this country for being discriminated. They are leaving this country for better livelihood and for better living and individual dignity. The individual dignity which was sought to be promoted by the Indian Constitution has been thwarted. People are being provided opportunities in the name of the caste, and some castes are being denied such opportunities. Let there be dearth of opportunities or financial resources. How individual dignity is also lacking in India. Why it should be reserved in favor of any particular castes? By enacting SC/ST Atrocities Act, certain castes are protected while some other castes are exposed. Honorable Indian government ought not to have done that. It is a serious discrimination which is against the Constitution. It is not just violation, it is destruction of constitutional objectives, as a result of which people are not able to mingle with each other socially, politically, financially. Great injustice is being done to downtrodden communities. Everything is being done in the name of castes in India. It is the government which is responsible for that. Supposing we remove few families from scheduled castes, scheduled tribes and backward classes, they may be hardly 0.5% or maybe even 1%. Yet, you will be implementing reservations to castes which have 99% of its population. In due course, the creamy layer become again backward classes in terms of socially and financially. So, it is an unnecessary and controversial issue to take up creamy layer theory. I told you, any help must be done under the Constitution to individuals who actually deserve it. By doing so, do the scheduled castes and scheduled tribes and backward classes would lose their benefits? They are anyhow backward in terms of their financial resources. They will anyhow get sops from the government. Supposing they are financially well off, being scheduled castes, scheduled tribes and BCs, then they do not need reservations at all. So the justified policy would have been to provide reservations based on individual needs, not by castes. These backward classes, please remember, they are termed as OBCs, means other backward classes. If these are other backward classes, who are the another backward classes? It is scheduled castes and scheduled tribes. Nowhere it is written in the Constitution or any law. But it should be understood that scheduled castes and scheduled tribes are inherently backward classes. So the backward class lists cover scheduled castes, scheduled tribes and notified other communities whom we are calling OBCs. As such, please understand the ongoing agitation by backward classes for 52% reservations in politics, employment, etc. is a misnomer political slogan. Backward classes includes scheduled castes and scheduled tribes. Without their inclusion, how there can be an agitation for benefits of backward classes? Of course, the government has resorted to subclassification of backward classes as Group A, B, C, D, etc. Whereas, in case of scheduled caste and scheduled tribes, so far such a subclassification is not there. Manda Krishna Madiga has been agitating for classification of scheduled castes since he felt that his community, namely Madiga, was not getting adequate reservations in comparison with Mala community. But please understand, this is not a fight between Madiga and Mala. There are several other small communities in the scheduled caste group which do not have any voice. They cannot agitate. They are financially weak. They are voiceless. So it is not the intention of the constitution to provide reservations based on caste in matters of employment. So the first constitutional amendment providing reservations to scheduled castes, scheduled tribes and backward classes based on their caste was unconstitutional. This creamy layer policy is again unconstitutional. It is also nothing but caste reservations to the exclusion of hardly 1 or 2% of them. So in terms of the Honorable Supreme Court judgment in Champakam Dorairajan case, reservations in employments cannot be provided in caste names. But however, as regards political reservations are concerned, the Constitution provided political reservations to scheduled castes and scheduled tribes under Article 330 and 332 for 20 years, as decided by Article 334. So we can understand that providing political reservations is in tune with the ideology of the Constitution. As such, the 73 and 74th constitutional amendments brought by late Sri P.V. Narasimha Rao garu, consequent insertion of Article 243D and 243T and their Clause 6 providing reservations to scheduled castes, scheduled tribes and backward classes in local body elections is perfectly in tune with the ideology of the Constitution, because political reservations were accepted by the Constitution, but whereas a livelihood, opportunity or job reservations cannot be made on basis on the caste. This was the opinion of the Honorable Supreme Court and it was distorted by the first constitutional amendment. In fact, when a Supreme Court verdict was bypassed or circumvented by subsequent amendments, it is the duty of the President of India to withhold such bills. President of India must belong to a political party. He must be a politician because he has to solicit votes from the various MLAs and parliament members. Unless he has relevance in giving B forms to them or winning the elections by them, how can he solicit votes? Council of Ministers are his appointed subordinates, so the President and Ministers should belong to one political party. And in terms of Article 78, the Prime Minister was duty bound to report all administrative and legislative proposals to the President and provide such of the information which the President may call for. Unfortunately, the first President being elected by or with the support of the then Prime Minister, he has abdicated his responsibility, his constitutional obligations towards the people and started signing and stamping whatever sent to them, whatever sent to him. Thus, he voluntarily became secretary to the Prime Minister. Since the same political party and family ruled this country for 30 years from 1947 to 1977, it has become practiced by precedents. However, Indira Gandhi sought to regularize this irregularity by introducing 42nd Amendment to the Constitution to the effect that the President is bound by the advice of the Council of Ministers, that the Constitution was thoroughly distorted, demolished from the very first era of its passing. Through the first constitutional amendment, I do not say that scheduled castes, scheduled tribes or any other backward classes should not get help from the government. They should get all possible help and much more than what is being given now by way of facilities and financial assistance. But employment cannot be given. If you look at the preamble, justice, liberty, equality, justice of social, political, economic, that means you have to do justice in matters of social, political, economic. In doing justice, there may not be equality sometimes. But whereas the third objective, justice, liberty, equality, equality in status and opportunity. While dealing status and opportunity, equality is paramount. It cannot be violated in the name of giving justice or whatever. Equality cannot be sacrificed in matters of opportunity and status. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. and I will be glad to respond to your worthy comments. Thank you very much.